Hello, my name's Karen Gibb from Menzies People Solutions, and welcome to this short information session to give you an update on a recent change to holiday pay and allowances. I'm joined today by Andrea Tishler from GBH Law, and I've asked her to come and join me for this short discussion around the recent Supreme Court judgment in Harper Trust and Brazel, because it has presented us with some challenges around understanding how to deal with holiday for part-year workers. So welcome, Andrea. Thanks for joining me. We're going to just try to shine a light on this and bring a little bit of clarity to it. Is this a decision that you've been waiting for a while?
Yeah, it's certainly a decision that has been going through the courts and has now reached the Supreme Court, and we've had the decision from the Supreme Court very recently. And as a consequence, it is now the case that there isn't going to be any further appeals. There's nowhere else for it to go. So we are stuck with this. And unless there is a change in legislation, effectively, employers really do need to take on board what the decision means for them and look at the impact on them.
Okay. Before we go any further, then, could you just explain? There's a lot of in the judgment. There's a description of a part-year worker. So can we just be really clear what we mean by part-year and the types of working arrangements that this judgment is going to apply to?
Yes, certainly. So the individual in this case, Leslie Brazel, she is a music teacher, and she was on a 0 hours contract. So she didn't have any obligation or entitlement to work any particular number of hours in a given week. She was effectively just working as and when needed, and there was a disagreement about her holiday pay and be paid that holiday pay. And this is very relevant to obviously 0 hours contract workers, to casual workers, to part-year workers, term time employees, who effectively just work for a part of the year or an as and when needed basis during the course of the year. But they have an ongoing contract, so they're being retained and to work when needed.
Okay, so the difference here is that they are an employee of yours all the time. So their contract is in place for the whole year, but they might only work a certain number of weeks of that year.
Yes, indeed, they're either an employee or indeed a worker, and they have an overarching agreement in place, but effectively they're only working part of the year or on a casual or 0 hours basis. But there is an ongoing agreement sitting above the arrangements.
So what I would have is two different types of worker here. I may have a part-time worker who works throughout the year, 2 days a week, every week of the year. And I won't change anything about how I treat their holiday. A week for them is 2 days. They're entitled to 5.6 weeks in the year, and I will prorata that holiday according to the hours they work per week. And that's unchanged.
Yes.
Where I have a part-year worker or someone who works irregular hours, what I would have done is I would have taken the percentage approach of the 12.07% of the hours that they'd worked.
Yeah.
And I would have then calculated that as their entitlement and the payment that they were due for their holiday. Now, that's the bit that I'm not going to be able to continue to do anymore, because I have to accept that they are entitled to 5.6 weeks, regardless of the number of weeks that they may have worked in the year. So I've now got to get a grip of calculating what is a week's entitlement and a week's pay for them. I know I owe them 5.6 weeks, but what is my approach now with what is a week for them?
Interestingly, that was what a lot of people were doing. That's indeed what the ACAS guidance was telling us to do, and that is now no longer correct. And there needs to be, employers really need to revisit how they have been doing those calculations. And the starting point for them is that if they have workers and employees who they are retaining on a year-round basis, so irrespective of how many days or weeks they're working during that year, if they are being retained over the course of the year, they are entitled to 5.6 weeks of statutory holiday. That is irrespective of how many days or weeks they're actually working in that year. That is the starting point, 5.6 weeks statutory holiday if they're being retained over the whole year.
So if I was sitting in the office as my, on my 0 hours contract, and I'd done, I don't know, 26 weeks of the year or something, but I was sitting next to my colleague and she worked throughout the year, but she was on part-time hours, with proportionately for the hours I work versus the hours she works, I'm going to end up with more holiday.
Yes, potentially that is the case. Potentially you may well have more holiday entitlement as relating to how many days or weeks are actually being worked. But that is the case, that the entitlement is there. If you are being retained over the course of the year, that is what you're entitled to. The next question, part 2, is what that looks like in terms of what your holiday pay calculation actually is. So what is 6 weeks holiday? And that's the next step in the equation, is really to start with, we don't prorate, it's 5.6 weeks because I am on a contract that continues throughout the course of the year. That's my entitlement, but what does that actually look like in terms of the holiday pay?
Right. And what should be our approach with the pay then, in terms of how do you work out that payment now?
So you need to get an average weekly wage. So you're looking at the pay average out, and the averaging period is now 52 weeks. So you go back over 52 weeks. However, you discount any weeks where there's no work being done at all. So the intention is that you attempt to get 52 weeks where there has been some work performed. You only go back over the previous period of 2 years. So if you get to the end of the 2-year period and you don't have 52 weeks of worked time, you would still use whatever period you have got that includes time being worked during those weeks. You average out over those number of weeks, whether that's 52 or less. And then you're then calculating 5.6 weeks of that average pay, the average weekly pay.
So when we've got somebody on a contract that's going to continue throughout the year, it doesn't matter how many weeks they actually work in that year, they are entitled to their 5.6 weeks.
Yes.
That's so the allowance part of holiday is absolutely clear. The payment part of holiday, and the amount that they get to take in those 5.6 weeks. If during my working time I normally work 2 days a week, my holiday will be 5.6 weeks of 2 days per week.
Yeah.
Okay. That might mean I end up with more holiday than proportionately a part-timer who works 2 days a week, 52 weeks of the year, but we are where we are. The allowance is absolutely black and white. And what you're saying is, for the pay, you'll need to look back for the 52 weeks where the person worked, look at their earnings, and then determine what their holiday pay should be. Going back further, if you've got unworked weeks in that 52.
Yes, so you're trying to get an average over 52 weeks, or it may end up being less depending on how many weeks they've worked during those 2 years.
Okay. Let's talk a little bit then, because this is quite a challenge, I think, to communicate and to rationalise with our clients. I realise it's a done deal and we have to get to grips with it. And I just wondered what advice you're now giving for the next steps for your clients, and how to come to terms with this and essentially put it in place.
It needs to be a step-by-step process. So first thing you need to do, do you have 0 hour staff? Do you have casual workers? Do you have part-year workers? And are they retained on a year-round basis? Or are they effectively just employed for short periods of time, and there is actually a termination and re-engagement as and when you need them to work? So that's what we're looking at first of all. So you're doing an audit effectively to find out whether there are any staff who are affected, any employees or workers who are picked up by this decision.
Okay.
And then if you do have people who are likely to be affected, then you need to look at obviously revisiting that holiday pay calculation. You need to be looking forward and saying, okay, well, you're now going to be entitled to 5.6 weeks. If we continue to engage you in the same way that we have been doing, and what is that going to be looking like in terms of the calculation that we need to make and what the holiday pay actually is. Obviously, you may want to make an assessment about changing the contractual arrangement going forward. Do you actually want or need to have them retained on an ongoing year-round basis? Effectively, if they are something like an exam invigilator, or they're just doing holiday clubs, or something where they're actually needed for a short period of time or short bursts of time, can you actually terminate and then re-engage them when they are needed? And then you are then obviously looking at a different arrangement. They are not being retained on an ongoing basis. You're just going to be paying what is due prorated for the period of employment.
For the period of the contract.
Yeah.
You've got all the inconvenience of that though, haven't you? You've got termination notice processes for them to leave. You've then got re-engagement processes coming back. It's a real balance, isn't it, of the admin cost versus just biting the bullet on giving them the holiday entitlement.
Yes, and that really is the consideration that you've got to make here. Is it going to be too difficult for us to go through that process every time we need to terminate and then re-employ, re-engage them? However, if you think about it, for somebody who's working 3 or 4 weeks, it really doesn't make sense to keep them on the books, as it were, for the full year. If somebody is working a number of months, it may be a case of we will just swallow the extra entitlement to the statutory holiday and keep the arrangements on an ongoing basis. Things like DBS, if that's relevant, there is an update service for an annual fee of £13, so you can keep that up to date even if there's breaks in the assignments. But yes, the admin around the dismissal or termination and re-engagement is a consideration to bear in mind.
Just to check that example you just gave me then, where you said if somebody's only working 3 weeks in a year, it's probably not worth keeping them retained. But if you did, would they end up with more holiday than they actually worked?
Yeah, yes.
Right. Okay.
And the question would be, why are we retaining them on a year-round basis? It might have just been, you have a bank of people, you just keep them on the books, just keep them retained. But the decision is that fine, if they are retained, then this is a statutory entitlement.
Okay. So look at your contracts, do an audit of your employees, determine who's affected. You obviously need to talk to them about the situation and make your decisions about how you continue to engage them, and immediately update your arrangements for their holiday and pay going forward. What about any historic entitlement? Is there the ability to claim any back pay in this judgment?
Yes, there is no, well, it's the decision is not that you automatically have to look at paying back pay. However, there is the ability for affected staff to ask for their pay to be backdated for a period of 2 years. So that again is a strategic decision. Are you going to actually open up a dialogue, communicate with staff about the decisions and what your approach is to back pay generally? That may then mean that you could get in a situation where you decide that you will apportion and pay what is owed over a period of time. I have some clients where that's the case, and they're saying, okay, we'll actually discuss this, and we're going to look at paying back month to month, so that that discrepancy over the past 2 years is covered off. Right. Or is it a case of actually sitting tight and seeing if this is something that is raised or not, and obviously rectifying the position going forward and making sure that that is sorted out. I mean, the question remains that if you start making changes to contracts and start changing the arrangements going forward, the question may arise, well, hang on a minute, doesn't this mean that this has not been done correctly in the past? Why is this change being made now? And why did you deal with it that way before if that wasn't correct? So it may result in those questions coming to the fore. Businesses take different approaches to this, and obviously it depends on the extent to which it's affected them and how they want to deal with it. Certainly what they need to be looking at now. Okay, all right, that's really clear.
Okay, Andrea, thank you. I think I've covered everything I wanted to ask you. Is there anything else that we should mention before we say goodbye?
No, I think really all I would do is urge people and businesses, employers, to really not ignore this and actually, look at the extent to which it affects them. Because obviously the longer they leave it, then they may just be shoring up a problem for the future. And to really take a step-by-step approach and to seek support and help as they need to in terms of contract changes and any calculations they need to be making.
Okay. All right, yeah, I absolutely endorse that. So we're going to put up a slide at the end. It will have contact details for Andrea at GBH Law and for me and our team at Menzies People Solutions. So for those of you who carry out that audit, look at your contracts, would like some advice, then our details are there to follow up with us so that we can understand the changes and implement what we need to. Andrea, thank you very much for the explanation today. It's been enlightening. Thank you. Bye-bye, everyone. Thank you. Bye.